Hi there, I'm Jim Zirin. Welcome back for more conversations. The question of the day is whether under our Constitution, a sitting president is immune from criminal process. Can he be subpoenaed? Can he be indicted? And how does indictment relate to impeachment? No president in history has ever been indicted, although one, Richard Nixon, in the Watergate affair, was named as an unindicted co-conspirator. Two presidents, Andrew Johnson and Bill Clinton, have been impeached, but not convicted. Nixon, of course, resigned under threat of impeachment. What are the issues? What are the considerations? And what are the closest precedents? Here to help us answer these questions is a real expert, a preeminent scholar and teacher of constitutional law, Samuel Issacharoff of New York University Law School. His latest book, published by Cambridge University Press, is entitled Fragile Democracies, Contested Power in the Era of Constitutional Courts. Professor Issacharoff, we're delighted to welcome you to the program.
Thanks, Jim. It's a pleasure to be here.
So let's start with subpoena. Can a president be subpoenaed to testify before a federal grand jury?
Well, that's unclear, as are most of the things here. We know a couple of things from past precedent. We know that his papers can be requested, subpoenaed, demanded by Congress and by federal investigators. We know that the president is not above legal process, which means that a president could be questioned on matters pertaining to his personal life. The example I always give is, let's say the president and his wife were divorcing and there was a child custody issue. There's no blanket immunity that the child has to wait 4 or 8 years to figure out who's the custodial parent.
But that's a civil case.
That's a civil case. But the criminal analogy is pretty direct. That is, that there is no guaranteed immunity from legal process. That stops, however, at the point that you raised earlier of impeachment or of criminal indictment or criminal conviction. Those have different constitutional components to them.
Well, let's pursue subpoena a little more for a moment. Suppose the president is subpoenaed and he refuses to testify.
Well, it depends subpoenaed by whom.
Say a federal grand jury.
Well, a federal grand jury could subpoena the president to testify, and I think under the weight of authority, he would be forced to testify, that there would be no immunity as such. The difficulty is, how would it get to a federal grand jury? It has to go through an executive branch officer, that is a federal prosecutor, and a president could stop that process well before there were an actual subpoena issued by a grand jury.
So even a special prosecutor who can't be removed except for conflict of interest, such as Bob Mueller.
Well, Bob Mueller's protections are internal protections to the executive branch, which means that he can't be removed directly by President Trump, but he can be removed with two signings of the pen instead of one. The executive protections for somebody in Mueller's position could be stripped away. He could be fired by the president. Rosenzweig could be fired by the president. It's very difficult to build within the executive branch itself a firewall that stops the president from doing effectively what he wants. There are political ramifications, and there are assumptions of how the office should work that may cause all political chaos to rain down upon him. But it's very hard within the executive branch to stop the president from having his will.
Now, you said there was precedent for a president being subpoenaed to testify before a grand jury. What precedent?
No, not for that. There's precedent for papers having to be delivered.
For papers, but
yes.
Not testimony.
Not testimony.
And Clinton testified before a federal grand jury in the Monica Lewinsky affair, but that was voluntary.
That was voluntary, and there was, given Clinton v. Jones, given the decision of the Supreme Court having to do with his amenability to legal process, it was pretty clear that some form of discovery, what we call discovery, some form of questioning of the president was going to take place, and he chose not to challenge it constitutionally. one generalizes from that to say that there's no blanket immunity to having to participate in legal process. But there's this whole apparatus about how disruptive it would be to the president's execution of his functions that make this a very complicated issue.
Well, he certainly with modern technology, he could testify on videotape. The prosecutors and the grand jury could go to the White House, so there'd be minimal disruption.
Right, Jim. When we say modern technology and videotape in one sentence, we already have a problem. But okay, he could testify remotely, and there's no question about that.
If the prosecutor agreed.
If the prosecutor agreed. The difficulty is not the physical act of having to go to some building in downtown Washington and appear before a grand jury. The difficulty, as we learned with the Clinton deposition, is that this creates an entire dynamic to the presidency that can be highly disruptive. And so if a grand jury said, okay, we want you to come at the very same time as you're supposed to be meeting with North Korea's leader, or that there's some crisis in some part of the world, one has to be very careful about the balance between the executive functions, which are critical, and these other matters that can wait, quite frankly. And the urgency of an indictment of the president or an appearance before a grand jury, it's very hard to figure out why that is so urgent, given the inability, in my view, to indict while in office.
Well, we'll get to indictment in a moment because, of course, that's extremely important. But can the president take the Fifth Amendment if
Sure.
he's subpoenaed to testify?
Sure, why not?
He's entitled to do that. And, but that has political ramifications, doesn't it?
All of this has political ramifications, and I think the key punchline in every one of these discussions is that our system is geared to having these matters resolved politically. And that's why the power of removal is placed in the political branch in the Congress, with both houses of Congress having to participate in it. We like to think that the greatest repudiation of a president is the next election, and is the ability of the American people to regenerate their faith in the proper functioning of our democracy. That's been our hope for 200 years, and the use of criminal processes in political decisions is a fraught undertaking for any democracy. As I tell my students, that as a general matter, any democracy that prosecutes its former head of state is generally referred to as a former democracy.
Or a banana republic.
Yes, that if it reached democratic considerations, yeah.
Now, if you or I were subpoenaed to appear before a federal grand jury and we refused, we would risk contempt of court, isn't that right?
Absolutely.
We might be thrown in jail until we decided to testify. Now, suppose the president refuses to testify and does nothing else. He's certainly not going to be thrown in jail. The marshals aren't going to come to the White House and arrest him.
He is not going to be thrown in jail. The marshals answer to him ultimately, and there will not be a constitutional crisis of this sort.
But it would be a political disaster, however.
That's the hope. The hope of any democratic nation is that the political accountability is what keeps our leaders in check. The idea that our main resort is to the criminal law, I think, is illusory.
Now, if he's subpoenaed, do you suppose he'll just fire Mueller? Or Rosenstein, or both?
I cannot speak to the political calculus of this administration. I have not understood it. I can't claim to understand it. I would have thought he would have fired Mueller quite some time ago. It is possible that there are calculations about the repercussions in the midterm elections if that were to happen. But that's the political dynamic. But he certainly has the power to do so one way or another. Now, it would trigger a spiral like the Saturday Night Massacre during the Watergate period, where if he demanded that Rosenstein fire Mueller, chances are that Rosenstein would resign. There's a chance that if the order were made that Attorney General Sessions fire Rosenstein, that would be trigger another resignation. You could have that kind of spiral, and that's a political liability. But there's no legal impediment. As a general matter, the The striking thing about this administration is not so much that it has been illegal in its conduct as so thoroughly anti-legal. That is, that there are certain norms of conduct that have been established over generations, over centuries, about the president doesn't interfere directly in criminal investigations. The president doesn't interfere with the internal operations of the Justice Department, not because he cannot, not because the Constitution prohibits it, but because it turns out to be wise to insulate the president from that. And this administration has devoted itself to transgressing those boundaries repeatedly. It turns out when they are challenged, these boundaries are informal. They're not hardwired into the Constitution. They're the way we as a nation have learned to do things. And this administration has challenged them. They've proven to be weak in many instances. And the normal boundaries of self-restraint just don't apply here.
Now, I heard Henry Kissinger, a non-lawyer, say that if he ever fired Mueller, there'd be a constitutional crisis. We hear that all the time, a constitutional crisis. From what you say, there'd be no constitutional crisis. He's entitled to fire Mueller.
Well, I think that when people use the term constitutional crisis, they're using it in an evocative way and not in a technical way. That is, they are using it to say that the legitimacy of the presidency would be called into question. And I think that's happened on a few occasions in our nation's history. It happened perhaps most notoriously with Andrew Jackson early on, when Jackson disregarded the Congress, disregarded the Supreme Court, launched one assault after another on institutions which were only taking hold. And the country got over it in a certain sense. Many people died as a result of Jackson's activities, but the institutions reformed themselves. We went through the period of the congressional challenge to Lincoln. Lincoln prevailed in that with the impeachment of Andrew Johnson. Certainly the participation.
He was narrowly acquitted.
He was narrowly acquitted in the Senate. And then we went through the period of orchestrated illegal conduct from the White House in the Watergate affair. All of these were constitutional crises in the sense that they called into question whether the institutions would hold, but they weren't in a technical sense a constitutional crisis. The institutions more or less performed as they were supposed to, including holding of impeachment hearings and things of the sort.
Okay, so let's move on to indictment. If you or I were subpoenaed before a federal grand jury and we decided not to go, one risk we might have, or if we took the Fifth Amendment, one risk we might have is we'd be indicted. Can the President of the United States be indicted while he's in office?
I don't believe so.
Well, let's try to divide it conceptually. Suppose, as the hypothetical that he used in 2016, suppose he shot someone in 2016 on Fifth Avenue before he took office. Could he not be prosecuted for that crime?
He certainly could be prosecuted.
That means he'd have to be indicted.
That means he would be indicted for acts committed before he was President of the United States. But in order for that indictment to go forward, I think he would have to be removed from office. I think that it is difficult to indict or prosecute a sitting president for a variety of reasons. Now, to be fair, there's no direct precedent on this. There's no direct authority.
I mean, Nixon was named as an unindicted co-conspirator, but he was never indicted.
He was never indicted. So there have been two attempts by the Office of Legal Counsel, the Department of Justice, to try to get their hands around this question. Once during the Watergate period and once during the Clinton period. And both times they came to the conclusion that the answer is probably not. And it's interesting to go back and read their theories of why not. And their theories changed in each instance. And their theories are just slightly different than the ones that I would have. But they all come to basically to the same end, which is it's structurally impossible for the president to be indicted. First of all, who would indict him? It would have to be a federal prosecutor, but all the federal prosecutors work under the president.
Well, a federal grand jury, because what's notable about the conclusions of the Justice Department is that the special counsel, the analog of Mueller in both cases, in the case of Nixon, Jaworski, in the case of Clinton, Starr, Ken Starr, both said the president in office could be indicted.
He could be indicted, but then he could not be prosecuted criminally during that period.
So isn't it for the court to say, well, all right, you've indicted a person who is the president of the United States, perhaps for pre-inaugural conduct, and maybe you had a good reason to do that because of concerns about the statute of limitations or some other reason, but we'll stay it until the president leaves office.
That would be fine.
And that's consistent with the Constitution.
I think that would be consistent with the Constitution. But Jim, as you recall from your experience as a prosecutor, courts don't act on their own. They're not self-activating entities. Somebody has to stand before them.
Well, Trump's lawyer, or the president's lawyer, would say, Your Honor, my client, as you know, is the president of the United States.
Yes.
He's a very busy man, and it would be an effrontery to the office and interfere with the conduct of the office if he had to stand trial while in office. So let's postpone this until after he leaves office.
That's one side of the aisle. But who's going to be on the other side has to be a federal prosecutor who would ask that this go forward now. And that person is subject to the direct authority of the president. And so that's the problem that you have. It's hard to imagine how it would take place. But again, I return here to the main point, which is that the Constitution set this up to be a political matter, to be handled through the political branches. If the president were to be indicted by a jury in New York, let's say, for a murder in 2016, and that would likely go to a state jury, right? A state grand jury, it would be a state indictment. At that point, there's no state authority to prosecute the sitting president. That could never happen because that would give each state the power to destroy the federal government, something the Supreme Court has said is impossible going back now 200 years. What you have instead is the capacity of the political branches to react, say, we don't want a murderer as president of the United States. And the proper way of handling this would be to have him impeached by the House, removed by the Senate, and then just like you or any other person, me, anybody, that ex-president would be subject to the criminal laws.
So can the Congress impeach for pre-inaugural conduct?
Absolutely.
You think they can?
Yes.
But if you look at the history and the founders, they thought impeachment would only lie if there was an abuse of office.
If there was an abuse of office, but the language that they put into the Constitution is broader, and it's high crimes and misdemeanors, and
doesn't say when.
It does not say when.
So suppose he cheated on his income tax returns. Could they impeach him for that?
Well, there's two different questions. Should they and could they? Impeachment, in a very vulgar sense, is anything that the majority of the Congress decides it is. But in a sense of being governed by the rule of law, no, they shouldn't impeach him for that. He should be subject to penalties or whatever to be executed after he leaves office. There's no urgency to that.
But Clinton was impeached for perjury about his affair with Monica Lewinsky.
Yes.
Should a president be impeached for something like that?
I think that a president should not have been impeached under those
circumstances. Because that's not an abuse of office.
It's a derogation of the decency of the office, but it's not an abuse of the office as such. I think that the Clinton impeachment was a low point in American democracy. I think that it was an effort to derail a presidency for political reasons using impeachment for that power. I think wisely the Congress in the United States has reserved impeachment for the gravest of offenses and has allowed the political process to have the repudiation of a president, so that after Watergate you had a Democratic sweep. Gerald Ford pardoned Richard Nixon. I think history has treated Ford well on that decision.
But not the electorate immediately afterwards.
The electorate immediately afterwards made its own choices, but in '76 you had a Democratic sweep, you had a Democratic president.
But an element was the pardon. The people didn't think the pardon was a particularly good idea.
But the pardon solidified the sense that this was the responsibility of that party in office, and the punishment was exacted electorally. I think that there were terrible things done in the name of prosecuting the war in Iraq by the second Bush administration, and there were demands by many to have some kind of criminal prosecutions coming out of the Abu Ghraib type situations. And instead, in 2006, you had an electoral repudiation of the Republicans in the midterm elections. And in 2008, you had the Democrats take control of not just the Congress, but the presidency. That's, I think, the way it's supposed to work.
Now, a prosecutor, as you know, is vested with a certain amount of discretion, perhaps an awesome amount of discretion as to whether or not to indict, even if there's evidence of a crime, when to indict, when it's appropriate to indict. And suppose you're Bob Mueller and you're looking at this situation, and face it, the majority of the House of Representatives as we sit here is Republican. It's unlikely to enact a bill of impeachment. As you said, it's a political process. And even if they did, it would be highly unlikely that 2/3 of the Senate would vote to convict. So he says the impeachment remedy, or he thinks that the impeachment remedy is inadequate. And when a remedy is inadequate, it's quite common that the law looks for another remedy. So he says, all right, now, at least if I indict him, I'll get all the facts out there. How disruptive could it be? Because if they voted a bill of impeachment, it would be equally or more disruptive. If I file a report, it'll be disruptive, saying that he committed crimes either before or during or whatever. So now's the good time to indict. What's wrong with that thinking?
It's a possible line of thinking. It's a way of upping the ante if he wants to. I think Mueller is a straight arrow. I think Mueller is
That's why he's there.
That's why he's there. He's as close as we get to Joe Dragnet, if you remember the old Just the Facts man.
Well, Ken Starr said that he was a Just the Facts man, and people didn't agree with him.
But Starr's report went so far after Clinton personally, and was so filled with salacious details that were unnecessary to anything that he was after, that he couldn't maintain that. Also, Ken Starr began looking at a real estate transaction in Arkansas a decade before and ended up with sexual activities in the White House. There was no clear trail that got him there, whereas this has been, from beginning to end, foreign influence over the presidential election of 2016 and potential foreign compromise of people in the Trump campaign and Trump entourage. I think that Mueller would be ill-advised to push the boundaries of his legal authority when it would only undermine the force of presumably what he is putting together.
Well, he's indicted Paul Manafort, and if you read the indictment, it really has nothing to do with Russian influence or interference with the 2016 election. It has to do with money laundering and tax evasion.
Yes.
But he is a law enforcement officer, and if he comes across criminal activity of any kind in the course of his Russia investigation, he's entitled to indict. Of course,
and that's what he's doing. And he is getting a number of convictions already. People have pled, and people are cooperating with him. And there's no question about that. But there's a difference between going after the small fry on the side and going after the President of the United States. And I think on that, he has to be cleaner than clean.
To go after the president?
Absolutely.
Impeachment isn't going anywhere, and as a practical matter, it's unlikely to go anywhere, even if the House flips. What's wrong with indictment?
I think that he could bring the indictment. He could. It's certainly within his power. I think it's not within his power to push it forward while Trump is in office. And if he did that, he would provoke the fight over the authority to bring the president to criminal prosecution rather than what the president has done. And the indication seems to be, from coming from the way he's conducted his investigation, that he's more concerned with establishing the fundamentals of what happened than in playing the political odds here.
Now, would indictment or impeachment lie if the facts show that Trump was involved in a conspiracy before he took office with the Russians to influence the election? But then he took office, and it has nothing to do with his conduct in office.
That would be the most extraordinary constitutional dilemma for us, because then you have a president whose very holding of the office is compromised, and is compromised by the activity of foreign influences upon us.
Okay,
obviously,
well, this has been marvelous, but unfortunately we have to wrap up. But I have a question for you, Sam Issacharoff, and the question is, can the President of the United States in office be indicted?
And the answer, unfortunately, is yes, but not prosecuted to conviction until he's removed from office.
That's marvelous. Thank you so much for coming by, and thank you for coming by. Tune in next week for more conversations. I'm Jim Zirin. Take care, and all the best.